Welcome back to the Law Unscripted, where we talk about the law and the legal system and everything you didn't know,
you didn't understand,
and no one ever told you. I'm Virginia Tehrani.
And I'm Chelsey Rogers.
And we are with Tehrani Law, LLC, because you never need a lawyer.
Till you do.
Okay, everybody. We're going to say immediately what we're doing today. Last week, we did murder.
Yes.
We did all things murder. So this week, we thought it appropriate to do all things defense.
Hey, look.
Of murder.
I think, if you're going to murder someone, you should know the defenses.
You should. You should.
Don't Google them, though, okay?
Yeah, if you're on trial, you do need a defense. If you're not going to take a plea, you need a defense.
Yes.
There's the standard defense of, I just didn't do it.
Yes.
Okay, that's
wasn't me.
Classic.
It's a Shaggy defense.
Right. Wasn't me. I am not going to sing on this week's program. I sang on last week's for the Maroon 5. This one, I am not going to sing Shaggy.
I can just hear it in my head.
I know. I'm singing it too. Maybe you are as well. Do you remember the ad a year or two, maybe 2 years ago, came out on the Super Bowl for the one with Ashton Kutcher?
No.
He and his wife, Mila Kunis.
Oh, I love her.
Did the Wasn't Me.
Did they really?
It was a chip commercial or something. It was so funny. They can't sing worth crap, but it was hilarious.
I love both of them. We're starting off with a tangent. I apologize.
It's okay. We've announced that we're doing defenses. We are going to get to them.
Yes. Okay. So this couple, I love them. I think they're adorable.
They are.
But they met on that 70s show.
Ages ago.
They're doing the remake. I mean, they're not in it, but
the
now there is
show, right?
The remake that is that 90s show. I watched 2 of the episodes.
Oh, no. Not so much.
Okay. Honestly, it's not as bad as some of the other, the Fuller House. Terrible.
Oh, yeah.
Awful. Girl Meets World. Terrible. This one I like.
Okay.
I will say, in comparison to the other remakes, it probably wouldn't be a show I would watch.
Are they on it?
Yes.
Okay.
At least in, like I said, I only got 2 episodes in, and Mila Kunis made an appearance. Ashton Kutcher, everybody did actually, except Hyde, because the whole thing there, the whole trial allegations.
Yeah, that's not good.
Aside from him, everybody was.
I did love that 70s show. I watched it.
Oh my gosh, I've watched it, and this is funny. Maybe 2, 3, 4 years ago at this point, I decided to watch it in order because it was always the thing that I would watch it when it was on, never sort of following the plot.
From the beginning.
Yeah, watch it through the plot. Now I will say, some of those episodes don't stand up to the test of time.
They were a one-time kind of thing. Yeah.
Truly. I was watching. I was like, that was assault. That was.
What you can't do that.
You can't say that, and you can do that. It's just like Friends. Anytime you watch it back through, you're like, ooh.
Yeah. It's it's okay.
Some things have changed.
I love the parents. They're hilarious and salty.
Yes,
I love
Red
them.
and Kitty. I love them. Adorable.
Yes.
So starting off strong with a tangent.
Yes, with a great tangent. So anyway, if you are charged with murder, as we talked about the different types of murder you could be charged with, from first degree, second degree, voluntary manslaughter, involuntary. We hit felony murder in there, which is sometimes second degree murder. But if you want to learn about the charges, go back to episode 9, I think. We'll put it in the links in the bottom.
I've given up the numbers at this point. Last week's
episode, I will put it in the bottom. So whatever episode this is, it's the prior episode on murder, on all things murder. So this is going to be the defense. And like I said, there's the standard, easy, I didn't do it. It's really not worth talking about it because you didn't do it.
Yes.
But the fun ones are that we're going to hit.
But
yes, I did it, but I have a justification.
Right.
So there are a couple of those, and we're going to talk about those today. We're not going to talk about insanity. That is a whole. That's going to take its own.
Yeah, because you just get into mental capacity in general, and that's just...
it really takes its own episode. So we'll come back to insanity by itself. But for today, we're going to hit self-defense, which is, I did it.
But I had to.
And then we are going to hit alibi. That's a quick and easy one, which is kind of fun. And then the third one that I think we're going to hit at least a little bit is intoxication.
Yes.
Because that is a limited defense. It is the same as self-defense of, I did it. Mm-hmm. I did do it, but I have some kind of justification.
Yes.
It's an imperfect justification is how it's called. But it is a justification, and it is very often only used in first-degree murder.
Yes.
So we will those are the ones that we're going to talk about. We're going to start with self-defense because it has so many different
And I think that's the one that you
options.
kind of, get the most misinformation about on any of the shows that we like to mention.
Everything.
And they even, obviously I'm a law student, but it is one of the more complicated, and because it varies greatly from state to state of
It does.
when you're allowed to use self-defense, with what force you're allowed to use.
Yeah.
Are you defending a person, like your person or your children? Are you defending property? Like there's so many different, characteristics. What am I trying to say? The different
options.
I don't know.
Wrong word, but
Words.
it's okay. You get the idea, and we are going to get it. So because it is difficult and it is different by state.
A lot. Yeah.
The basics are the same.
Yes.
You generally have to show 3 things, and I'm going to pull that out. So 3 things.
Oh, I was so glad you were not about to ask me because I truly was.
All right, Chelsey.
I think my heart
what's the first one?
I think my heart just stopped. 'Cause I was
Chelsey is not ready for the bar.
Okay. We're back at it.
Sadly, self-defense does not work for defense of your dog.
Honestly, though, okay, look, I have a lot of opinions about this. What do you mean? Because that's property.
They're my
I know.
kids.
The law treats dogs like their property, and I think that's not fair because this is my child. These are children.
Yeah, these are my kids. I have kids, but these are my kids.
That's what I'm saying.
I would hurt someone
over
my dogs.
Same.
So self-defense will not work. Defensive property will work if you're in your home.
Yes. Castle doctrine.
Castle doctrine. So I was going to say we'll come back to it, but let's go ahead and address that. So the castle doctrine is, I scared Chelsey with the other.
Of the elements, I was like, I can think of 1 out of 3 at the moment. So.
Yeah, so we're going to come back to that, but we're on the castle doctrine. So what is the castle doctrine?
The castle doctrine, and I actually do remember this, it comes from common law, from the English, that you sort of have an innate right to protect your home, your castle, right?
That's right.
Look at that.
That's very good. So yeah, you have a right to protect your home. Now, there are certain limitations on it. Yes. You have to be in an imminent threat.
Right.
Okay, so you have to have an imminent, immediate threat. This can't be something where you believe someone might be coming over to your home to do you harm, so you lay in wait.
Right.
That's not how this works. No. But if you're being robbed or burgled,
yes,
and you believe that you are an imminent threat of your life, not of your property, but of your life while you are in your property, in your home, then you do have the right to self-defense, even if that means you've killed someone.
Yeah, so deadly force.
Yes, so deadly force can be used.
Yes.
It doesn't necessarily mean it should be used or it's going to be excused.
Right.
And that's the elements we're going to get into. But technically you do, in most states or some states, have the castle doctrine, which applies. And in both Maryland and Virginia, where we work, it does apply. The castle doctrine applies, where you have the right, if you are in immediate, imminent threat in your home, to kill. Or to, to defend
to
defend yourself and to defend those in your home. There was that, it wasn't in our state, but recently there was that case of the girlfriend, the father who shot the ex-boyfriend who was coming into the home. Do you remember this?
No.
It's just a few months ago. So we're in 2023, and this was a few months ago in 2022, where they actually had the video. Wow. Of I'm almost sure I'm right, of the ex-boyfriend who was attempting to make entry into the home and had a gun.
I actually do.
Do you remember this?
I remember seeing this, yes.
And the father shot him and killed him. And whatever state it was in is the castle doctrine, is he had the right to defend himself. The video from inside the home seemed to bear him out that it was an immediate, imminent threat of serious physical harm, even to death. So he was defending himself and his home and against the person coming in who was trying to use deadly force.
I mean, we said it on the last episode. If someone's robbing your home and they think no one's there, okay, they're dangerous. But if someone is breaking in while they know you are there, they have nothing to lose.
Right.
It's the truth. Like they said, we said it last episode, and it's true. Anybody who's willing to do that is willing to do anything.
Yeah, they are coming in with intent to do you harm. And in this particular video, the man is heard saying, "Stop it." I mean, he's
like, "Go away."
You know that the boyfriend who's breaking in can hear him.
Yeah.
Like he knows he's there
he does
and
not
he's
care.
Still coming in.
That's so scary.
I mean, can you imagine if you're yelling out? Like if I had in my home, so let's do a hypo. I have 3 floors and my office, as you know, is on the top floor, right? And I look at my desk is at a window. And I look outside and I can see the front of my house and the driveway and the main street. And I see all of the people in my neighborhood who walk their dogs. And I track them. Okay. So this one particular lady, she walks 3 times a day.
She's her little hot girl walks.
She does 9 to 5, 3 times a day. And then there are others who walk in the morning and then again in the afternoon. So there are the 2 timers. But I can see what's happening.
Yeah.
And I will tell you that if I were to see someone during the day who is trying to come into my home, who's not UPS, who's not FedEx, who is not Amazon drivers delivering all of our packages, I would, the way to do it is, to announce yourself if you can.
Yes.
Get away.
Yeah.
I'm calling the police. Stop. Don't go any farther. I wouldn't stick my head out the window.
Best practices, but the law is kind of...
The law is clear. If someone is coming in and breaking into my home with a weapon, I mean, it's best practice to call out to tell them to stop. But if you are not safe to retreat, even in your own home,
right?
If you're not safe to retreat, I mean, how am I going to, if the person's trying to come in, am I going to make it out the back door in time? I don't know.
Yeah.
Is it safe to go somewhere else in my house? I don't know.
I think the best defense is a strong offense, right? I mean,
right.
And truly, especially in these situations where you're talking about in your home, and I think the law, it carries over from common law throughout all of it, is the home is sort of treated differently than anywhere else.
Absolutely.
With our privacy laws, it's treated that way. So it's no shock to me that sort of in a self-defense sort of thing that the home is treated differently. And it feels very different. Even to me, all these, hundreds of years later, looking at it, like defense in a home seems very different to me than like defense anywhere else.
Yeah, if they pass your moat, then they mean to get to you,
I mean, that's really what the
if
concept
they're in my garden,
then I mean, like I said,
that's the idea.
Yes.
But yeah, so
it's so scary.
You do have the castle doctrine, but even with the castle doctrine, you still have to meet those elements.
Yes.
So
what are these elements? I'm so
practically in tears what do you have to
I know one
show?
of them. I was like,
okay, well, tell us the one that you know.
Imminent danger. To me, that's the big one, is that you can't say, I'm just lackadaisically waiting for them to, go through my entire house and then I'm going to pop out and shoot them later.
Right. You can't jump them.
Right.
Right. This is not, they haven't, if they're just looking for your stuff, again, it depends on every prosecution.
Yes.
Is fact specific.
Absolutely.
And that is the thing, is what happens in one case doesn't happen in another. They may be similar, but each of the facts has to be reviewed and determined individually for that case.
And that's why the defense is allowed to be put on, and then a jury looks at this and is like, would I have done that? I think a lot of the time is what the question is.
Well, that's the second element. Okay. So you've hit it without realizing.
Reasonable person.
Reasonable person.
So dumb. I literally said this last week.
This isn't dumb. This is you putting it all together.
There we go.
So you have to have an imminent, immediate threat.
Yes.
It can't be perceived as, well, maybe it is, or it would be next week, or I think it might happen. It has to be imminent and immediate. and it has to be a reasonable belief. Okay. So you have to reasonably believe that it's imminent. And that is part reasonable person, any reasonable person, and part specific to that person.
Yes.
So there's, like we said before, there's these imperfect defenses. And one of the imperfect defenses for self-defense is, okay, I really did believe I was in imminent danger.
But it was not a reasonable belief.
But it wasn't a reasonable belief. So you may not be completely exonerated of the crime.
But it's like a mitigation.
It's a mitigating factor. And maybe you would get a lesser. So if you were charged with first-degree murder and you presented self-defense and a reasonable person wouldn't have believed it, but we believe you believed it.
Yes.
Then maybe it's second-degree murder that you're convicted of. So it's a lessening, it's a mitigation, it's an imperfect self-defense.
It's like I guess this would be a reasonable belief, but it makes me think of sort of even the mistaken belief where, the husband walks in on lovers, his wife and their lover, and he assumes it's an assault.
Right.
That's like a mistaken belief, I guess, instead of a not reasonable.
It's the mistake, and that's another imperfect self-defense. Is there's the imperfect, well, I really believed it, even though a normal person wouldn't, and then there's the I made a mistake.
Yes.
I believed I needed to, but it was a mistake.
Yes.
It was like if you believed you were walking in on your wife and a lover, but it ended up being your kid who'd had a nightmare and was sleeping in the same bed as your, as your wife, and you come and you shoot them both, and now you've shot your child.
Yes.
Well, these are imperfect defenses.
Right.
Okay. So you believed that someone was pulling a knife on you.
Yes.
These are a lot of the police ones. The mistakes are a lot of the police, where if the police officer believed that a gun was going to be pulled out, someone reached for their pocket. Right. They told him, don't move, don't reach for anything. And the guy's like, but I just need to get, and they reach for their pocket. The police officer thinks there's a gun, but it's a mistake. It was his wallet.
Right.
Right. So this is the type of self-defense.
And then it comes down to, does the jury believe that was a reasonable mistake?
Correct.
Okay. So we got a couple different options there.
So there's that, and then there's the third, and I am going to pull out, I have notes again here. I have to have notes. Now this, I didn't actually write these, which is really shocking. I just pulled the book out. But there's this handy little book that has all of these, at least for, again, these are general.
Yes.
They're fairly well accepted in most states, but each one has a little bit different.
Absolutely.
Little bit of a difference. So you have to look up your state. But for the general majority, the third thing that you have to prove, let me make sure we've got, okay. So, we've talked about the imperfect. Where's this? Specific defenses. Maybe it was on my cell phone. This one might have been on my cell phone. So I'm now going to use my cell phone, but I swear there's three.
Let me see if I can brainstorm it. Okay, we've got a reasonable belief.
Yes.
Imminent danger. Do you have to do appropriate force?
Yes. So there's the reasonable belief that they're in imminent danger, which goes into, you can count it as another or combine it. I combine it in an actual belief. So there's the belief of imminent danger. There's the imminent threat.
Okay.
And then there's the absence of provocation. You didn't start it.
Oh, that is true. Yeah.
So you can't have started it.
I can't pick a fight, get someone to fight me, and then be like, perfect.
Right. And then it's self-defense. No, if I come at you with a knife and then you use a knife to kill me.
Right.
I'm not defending myself. You're defending.
Right. This is mutual combat, right?
Now it becomes mutual combat. And oh my gosh, speaking of mutual combat, it doesn't work for every state. But there are some states where they will say, okay, it's not self-defense, even it's mutual combat. They both got in a fight.
Yes.
And one or both of them is charged. And I had I had several cases when I first started my career in Virginia. I was doing a lot of criminal defense as a court-appointed attorney. And I had at least 3 cases within a year where it was like girls fighting. Okay. And
girl fights are scary.
They are scary. They are serious. And they were both charged with assault and battery, or one was.
Yeah.
Okay. And I would have at least one of the girls. And it was so fascinating because I would present this defense of it's not self-defense, it's mutual combat. Where say they picked a fight. There was the one girl, they had she was cheating on she was cheating with the boyfriend. Okay, so there was the girl and her boyfriend, and then the lover, right? So she cuts her off driving down the highway, cuts her off. They both pull over, and she starts pounding on her.
Oh, just on the side of the highway?
On the side of the highway. So they get in a fight on the side of the highway, and I was like, look, it's self-defense because, you know, that girl cut her off, got out of the car, approached her.
Hey.
What was she supposed to do?
Operating your vehicle. Hey, vehicles are deadly. You can make it...
Right?
If you're going to operate that in a dangerous manner intentionally at me...
Absolutely.
I think self-defense.
They get in a fight, and it was so funny because I thought I had proved self-defense.
Yeah.
But the judge let her go. He found her not guilty, but he said it was mutual combat. So in his mind, it was mutual combat. In mine, it was pure self-defense. But either way, she was exonerated. But then there were two more within 1 year where it was mutual combat.
See, okay, I know in Texas, you can mutually, like you can fight and you can not, like you can, there's a statute in Texas. It's very interesting. You know, one of the wacky laws, I truly don't know how often this is actually used, but in Texas, you're allowed to engage in mutual combat if both parties agree. Which I think is hysterical.
Like a duel, right? Are we back in the 1800s where we're dueling?
That's why I'm putting the caveat. I don't really know how often it's used now, but that's sort of the concept. My unpopular opinion, look, I think this is such an unpopular opinion. I think more people need to get hit at least once, right? I'm not talking about really terrible fights, nothing, but some people deserve to get decked just once. Like, they would not run their mouths the way they do if someone had just punched them in the face one time. That's it. Right? Like, I don't want people to get seriously injured. I'm not, like, talking about violence, but some people just need to be decked one time.
We're looking for a criminal defense attorney for Chelsey. If anyone has any suggestions, we live in Maryland. She lives in D.C.
I was going to say, there might be some issues down in Georgia.
We need an attorney if you know of one. Yeah, so there's this. Okay, so that's the third. So yeah, you can't have been the aggressor. Now there is an exception.
Okay.
Most states have an exception, and the general exception, and it is hard to prove this exception. Okay. Let's say you go in with a knife. Mm-hmm. Okay. I come at you with a knife. Mm-hmm. You have the right to defend yourself, right?
Okay.
Now, generally, I would not have the ability to do self-defense. I came at you with a knife.
Right.
However, if I stop the fight and I walk away, I retreat, and I actively tell you, I'm done, we're stopping, no more, and I walk away, and then you come after me, now I have self-defense.
Oh, that's interesting.
Mm-hmm. So you have to have stopped everything, have actually indicated in a very good manner. Okay. It can't have been, like a subjective, well, maybe he stopped it. Like, it has to be clear.
So this is, you're talking about back completely turned.
Yes, you have to have made it clear that this was ending. You were stopping. You were no longer going to be involved. You were walking away, and you retreated.
Interesting.
And then it's almost like Tyree Nichols. So I'm going to come back to that.
Yeah.
So it's like if the officers had said, well, we were doing self-defense for the first part, right? Mm-hmm. And at least one of the officers has alleged that the first part of this beating was self-defense.
Yes. Because he filed the police report saying he was a victim of assault.
Right. Yeah. That the allegations, at least by one or more of the officers, were that he was grabbing for their guns. Right. He was putting up a fight. So maybe they can claim self-defense. But as soon as he ran... Right? He ran away, according to the facts that are coming out. He ran away, and the fact that they ran after him... then even if he had provoked them, then the fact that he ran away, then he now would have a self-defense argument.
Right.
So anyway, a little bit of a real world application of how it works. But
that's interesting.
Once you run away and then you're tracked down, then that would be, assuming he even needed a self-defense argument. Okay. Then that would be how it works.
So we've talked kind of about the castle doctrine, sort of the elements of self-defense. What about, I think these are the more interesting cases, self-defense in places that are not your home. So, in public places, you talk about walking down the street, any of those type of cases.
Absolutely. Well, I think one of the best ones and easiest examples is if you're mugged.
Yeah.
Right? You're on the street, you're walking down the street, you're in D.C. It's terrifying to me to walk in D.C., especially at night. If someone were to jump you, if you believed that you were an imminent threat, then you would have the right to defend yourself.
Interesting.
In public.
Okay.
So it doesn't matter where you are. If you are accosted, if you were mugged, if a gun is held at you, if a knife is held at you, you have the right to defend yourself.
Okay.
Because we've got imminent and immediate threat.
Right.
We have, what else do we have?
Oh, we were just talking about a reasonable belief.
Yes, a reasonable belief that you're an imminent and immediate threat. And
we were just talking about it. You didn't provoke it.
Correct. You didn't provoke it. So reasonable belief, the immediate threat, and you did not provoke it.
So well, I'm bebopping down in Washington, D.C. because I refuse to not get to do what I want to do. I bebop everywhere any time of the night.
The fact that you're saying bebop,
because I just can't. I do what I do. So you're saying, okay, someone tries to mug me. I think they have a weapon. Maybe I can't see it. They're behind me. Give me all your money, whatever. If I mug them back,
mug them back.
I said, no, you give me your money. They can't say self-defense because they instigated it, right?
Generally so. I mean, you were attacked. You have the right in whatever weird way you would like to defend yourself.
Yes.
If that is your way you choose is the best idea to defend yourself.
Gotcha.
Then yes, technically you would have that right.
Okay, good. Glad to know that. And they would not be able to do anything about it.
Not unless they stopped it somehow and retreated, right? And then you ran after them and you're like, no. You started this and you ran after them or you shot them in the back.
Good to know.
Then no. And that's with the castle doctrine too.
Yes.
Right? If somebody is actually leaving your home, let's say you announce, don't come any further, don't approach my home, and they start leaving, you do not have the right to shoot them in the back.
Well, that takes away the imminent threat part of it, right?
Exactly. It takes away the imminence, the immediacy. It's no longer reasonable if they're leaving. I mean, still call the police. Goodness.
Right.
Still make sure you're protected. Still make sure they're not going to come back. But if you see that they're leaving, then generally it is you can't shoot them in the back.
Right.
You can't shoot them as they're walking or running away.
Which makes sense.
And that's with, any place, but especially your home. That's where the castle doctrine stops. Okay. They're like, no, you can't do that. And you also can't set up booby traps.
Oh, yes. Oh, this is the...
I love this one. No bombs in your house that would go off if stepped on, okay? Yes. Just don't do it.
You cannot rig up a shotgun that when a door is opened by trespassers, boom, blows them to pieces.
That is a classic case used in law school.
I can see the picture of the little barn house shed thing in my mind because that was wild to me.
Yeah.
And the whole thing about that one is super obscure, but he initially had it at the height of people's heads. And his wife was like, hey, honey, let's not do that. And he was like, okay, you're right. Knees instead. And like, I'm sorry, what?
Yeah, you don't have the right to set a booby trap that would actually kill or harm somebody if you're not there. Because it's not an immediate threat to you.
Right. And that is just a response of to trespassing, that is a
it's a very insane response to trespassing. Now, you are allowed in most states to set up things like barbed wire.
Yeah.
Like in your fence, you can set up a fence and you can set up barbed wire if you want on your fence so that people can't come in, but they wouldn't die. You're not like putting a trap where a gun goes off or a bomb explodes or fire breaks out.
Yes. And since we were talking about it, in that case, the big difference is that this was a shed. This was not where he lived.
Correct.
If that had been his home, I mean, I don't know. Maybe if you're talking about your bedroom door inside your home and you want to rig it up, I don't know how a court would rule, but possibly. Right? That's a different really level of sort of invasion there, right? In this case, it was like an empty barn on like acreage away from his property that he was just mad about people peeking into. They weren't even damaging it. They were just kind of poking their heads around.
Your outhouses, your sheds, your pool house, that is generally not considered your home as part of the castle doctrine. Right. And generally, even if it's your home, you can't rig up shotguns.
Yeah, so I don't think, like, I think
not
that
allowed.
It's if you have time to do that, like you're not in imminent danger.
It's the imminence.
Home Alone style. Right. Like,
absolutely. It's the imminence. And that is one of the key factors that you have to prove. And this is where it gets to proof, right? Yes. Generally, the prosecution has the burden of proof. They have to prove beyond a reasonable doubt that the defendant did it. Now, if you claim self-defense,
burden shift.
It's a burden shift. The defense has to prove self-defense. Now,
it's an affirmative defense.
Exactly. You were saying yes, but. Yes. So you have to do a level of proof. It is not the same generally as beyond a reasonable doubt. In most states, it is a requirement of production. Where you have to produce information and facts and substance, some evidence that is reasonable for self-defense.
Yeah.
And once you make this level of production of evidence, then the burden shifts back to the prosecution. And depending on your state, you have a different one. So in Virginia, you have proof beyond a reasonable doubt. Okay, so it shifts back where if they present self-defense, the affirmative defense with proof, then it shifts back to the prosecution to prove beyond a reasonable doubt that it was not self-defense.
Right.
In Maryland...
Oh, is it different?
It is a burden of persuasion.
Okay, yeah.
So it shifts back. It does shift back to the prosecution, but it's a burden of persuasion, so it's beyond a reasonable doubt that the defendant did it.
Yeah.
It is by persuasion that it was not through self-defense.
Which is interesting because it's lower, right?
It is. It is a lower standard and burden of proof for the prosecution. Absolutely. Persuasion is more likely than not, and more than beyond, probable cause, but less than beyond a reasonable doubt.
I know. These always just freak me out, and because you're like, what does that mean to you versus me? Like, what is my more likely than not? What is my? And I guess that's why you put people in a room and say good luck.
Yeah, that's 12 people. You got to figure out, is it more likely than not?
Yeah.
So with the self-defense, I think the other key factor that we want to hit real quick, and then do alibi, which is very quick.
Yes.
And then the intoxication, which we may continue.
Yes.
And do that with insanity. You might have to put those together.
They kind of go together. I was going to say the last question I had was, do you want to hit stand your ground laws versus duty to retreat?
Well, we have some of that, yes. But I think the bigger one to hit is what type of force to use back.
Yes.
Because I think that's the biggest portion of, okay, you can prove that I was in imminent danger.
Right.
I can prove that it was reasonable to think that.
Yes.
And that I did not provoke the fight.
Yeah.
But what type of force?
To respond appropriately.
Is reasonable response.
Someone's backhanded me, slapped me across the face. I don't get to pull out a pistol.
Right.
Like,
and that's the unreasonable response. That's an easy response by the prosecution of, okay.
Sure.
He believed he was in danger, but the amount of force used in response was unreasonable.
Yes.
And therefore he can't use self-defense.
Right.
So you can't bring a gun to a knife fight type of thing, right? But maybe you can in self-defense and a lot of police officers will tell you sometimes knives are scarier when people are using them.
Did you know this? Oh, this is one of my fun facts. This is cultural. What people are more afraid of. They've done lots of studies across the world versus are you more afraid of guns or knives? Like, what is the sort of physiological response? It varies significantly by culture.
Really?
Yes. So in America, we generally tend to be more afraid of like knives.
Oh, I'm terrified.
To me, like
terrified of knives.
But it's like, it's very much a cultural thing of like, I think if someone held me at gunpoint, I would be less afraid than if someone held me at knife point. That's an American thing, right? Like it varies a lot country to country, and it's sort of just a cultural, like what is common, what is that? But I'm much more afraid of knives than I am of guns.
You can do some damage.
Yes.
Yeah, and the whole...
It's just more like an intimate...
It is. It's very up close and personal,
yes.
And so many things can be hurt and cut, and you can still be alive.
I just don't do blood at all. I know we'll just... You'll
just pass out.
Yeah, I'm like, you got me there. Done.
So, with that said, if somebody approaches you with a knife, then maybe there is a self-defense with a gun.
Yeah, I think that. For sure.
Because you can, especially if it's up close and personal.
Yeah.
What other defense do you have? Are you really going to use your hands when there's a knife?
I think it's also the thing of like, I mean, I walk around like I'm 6 foot tall and bulletproof, but like that's clearly not the case, right?
Right.
Maybe two men who are both 6 feet tall and 200 pounds getting into a fist fight. Them fist fighting is an appropriate response. I like to think it, but it's really not true. Like I'm not going to punch somebody who's 6'2" and 250 and it have any deterrence, right?
Exactly.
Like that's the reality of, okay, maybe another man responding with a gun in a fist fight situation.
Yes.
I'm sorry, if somebody that big is fighting me, I'm not going to rely on my right.
Yeah, and that's the reasonableness. And I think for self-defense, the biggest key for self-defense is reasonable.
Yeah.
Was it a reasonable fear?
Yeah.
And was it a reasonable response?
Yeah.
Kind of like shooting someone in the back. That's not a reasonable response to a threat. If you're in a fist fight and a knife is pulled, what is a reasonable response? Right. If a chair is being used or a bottle is being used, it is very fact specific.
Yeah.
This isn't something you can say, well, you can always use a gun and a knife with a knife. You can always use a knife with a knife. No, it is very fact specific. Yeah. What was happening at that time? Who was it? Is it the 6 foot tall, man against you?
Right.
Versus 2 men in a bar.
Right.
So you have to take into account the factors of who's being attacked, who's attacking, what they're using, what the environment is.
Yes.
And can they stand their ground? And that gets back to your point. Do you have to, most homes you can stand your ground, not all. Check your state. But if you're out in public, do you have the right to stand your ground? And it depends. In Maryland, you don't. In Maryland, you have the duty to retreat.
Which is fascinating. And that's the minority.
It is. It is a minority portion of proving self-defense, is you do have the duty to retreat. You have to try.
Which is so crazy. I'm sorry. That is crazy to me.
Yeah.
I just think, like I said, I walk around a lot by myself and like, I'm not trying to outrun somebody on the street. I'm sorry. Like, I'm not doing it.
Right. And again, it's fact specific.
Yeah.
So yes, you have the duty to retreat, but Maryland also says, unless it's unsafe to do so.
Right.
Okay, so if you're mugged by 2 6 foot tall men, burly men who come and get you, it is probably unsafe to run.
Right.
So you probably have the right to stand your ground and defend yourself. But it varies state by state. I don't think Virginia has it. I can't recall specifically.
No. I looked it up right before we started recording, and Maryland was on the list of states that I was like looking at just list really that had duty to retreat. Maryland was on it. Virginia was not. I didn't see DC on it either.
I don't recall. I've done very, very little of criminal anything in DC. I've done a couple traffic matters. Most of my criminal practice, criminal defense and prosecution was in Virginia. But honestly, this doesn't come up as often as the movies and TV want you to think that it does. Yes, it's used. Yes, it's a defense. Yes, it happens. But the majority does not use self-defense. as a defense. The majority is either I did it or I didn't do it. Is that wasn't me, that wasn't my pants, that kind of defense.
Okay, I have 2 questions to wrap it up with for you. These are practical questions. Okay. So we know that obviously in the past 20, 30 years, technology has increased a lot. There's a lot more cameras everywhere. There's a lot more video.
Very true.
So the whole wasn't me defense gets a lot harder when we have DNA, we have cameras.
It does.
Do you think that has impacted the amount of claims of self-defense as an affirmative defense? You obviously aren't going to know the numbers, but I
don't know that it's impacted the number of it, but I think it's certainly helped the prosecution to defend against it.
Okay.
Where with the burden shifting, I think it's a lot easier to say, look at the video.
Right.
One of my favorite cases. Oh my gosh, I loved this case. And the client was so nice. I liked him a lot. I was interning at the public defender's office in Alexandria, Virginia. So it wasn't my case, but I followed and shadowed on it, and it was a robbery of a convenience store.
Okay.
And the guy was saying it wasn't me. They got it wrong. It was not me. All right. There was fingerprint evidence on the counter, and it was his fingerprints, but they were saying, look, I've gone to that convenience store. It's right down the road. There's a reason for my fingerprints.
Yeah.
But there was a video. All right. And they showed the video, and the guy, he kept claiming that is not me. It's not me. It was a bench trial, not a jury trial. And I loved this judge, an older judge who's long since retired. And he says, wow, you put on a great defense. I totally understand the reasoning about the fingerprints. He had a really good, testimony. He's very credible. Except for the fact that I saw him rob the store. And it's like, okay, So video is very key in a lot of these, and especially the self-defense. I don't know that it prevents people from claiming it, but I think it certainly contradicts testimony a lot more than it used to, and maybe drives a lot more pleas of saying, okay, well, you can try that defense, but
come on. Okay, this is my last question then.
Yeah.
So this is the one I think is interesting. Normally, any criminal defense attorney is going to tell you not to testify, right? Like in your own defense. Generally, that's the rule. There's always exceptions, but that's sort of the don't testify.
Yeah, it's better not to.
But I'm curious, with self-defense, you would think it would be the opposite, right? Like if you're asserting that, I want to hear from the person who's saying, right?
Because you have to say what your belief was.
Okay, that was my question.
Right? It has to be reasonable. You have to say, so even if it ends up being an imperfect defense, the jury has to believe that you believed you were in imminent and immediate danger, right? So if they don't think a reasonable person would, but they believe you really did believe it, then there's the imperfect defense. So you really have to say something.
Okay.
It is an affirmative defense. It is very, very rare that a defendant will not testify.
That was my question.
If they're claiming self-defense. You can.
I mean, you have your constitutional rights, right? But the idea of being like, this was self-defense, but I am asserting my Fifth Amendment.
It's really hard. You almost have to completely give it up.
Okay.
So let me hit alibi really quickly.
So sorry.
No, please don't be sorry. This is good. Okay. Alibi is really quick.
Yeah.
I mean, it's almost a throwaway.
Yeah.
It is an affirmative defense where you're saying you're submitting some proof. It's not an affirmative defense where you're saying, yes, I did it. But, but it is a more affirmative defense because you're asserting something that has to have a level of evidence of itself. It does not generally rise to the level of evidence of production that then has to be disproved.
Right.
It's more of just a general defense.
Yes.
I have an alibi. I didn't do it. I have an alibi for it who will tell you I wasn't there.
My mother volunteering. That's where I was.
Mom's going to testify.
Right.
Now, the one trick to it is even though you don't have to prove it as a defendant, you just have to assert it. Generally, there are procedural rules that require you to give notice to the prosecution before the trial that you are going to assert an alibi defense.
I am so glad you said this because this came up yesterday.
Oh, really? In your class?
So I was talking to someone about something after class, but it was been wrongful convictions, which has been an interesting class.
Great class.
But that's what you were talking about is like generally defense theory, in my understanding, is that you don't reveal it. Like prosecution has to, there's Brady, there's all of the things, turn it over. And defense is like, you'll see at trial.
Yes.
And that makes sense. But in this is kind of what we're getting to is that it made sense when they said it, but I hadn't thought about it. You do kind of have to put the prosecution on notice because they then need time to investigate, right?
Correct. They need a time to rebut it, right? They have to have like if you say, I have an alibi.
Yeah.
Then the prosecution has the right generally to go and figure out who that alibi is.
Yeah.
And disprove it, counter it in some way.
Yeah.
So at least in Virginia, there was a little form when you got to the trial portion in circuit court that you had to check what was your defense if you were going to do an affirmative defense. And you had to give notice to the prosecution of self-defense or alibi. So alibi you didn't have to prove in the same way, but you did have to give notice.
See, I didn't. It was literally came up yesterday because I didn't know. It makes sense procedurally when you like extrapolate it. But in my mind, I was like, why would you tell the prosecution? But it makes sense when you think about it.
Usually you have to. Very state by state.
Just hit him with it at trial.
Right. I know, the surprise defense.
That's the Law and Order way to do it.
It is, and sometimes it happens, but it is very, very rare that it's
have a law clerk
surprise.
Rush in during the trial and like hand you something open.
I did have one surprise defense.
Really?
And I'm checking my time here.
Yes, I'm so sorry. I keep derailing our
saying you're sorry. Normally we would talk forever, but I do have a phone call very soon, which is not normal while we're doing our podcast. But one of the most upsetting cases I ever had, you've heard it before, and this was a surprise. It wasn't an alibi. It wasn't. And it wasn't self-defense.
Yeah.
It was the classic, it wasn't me.
Right.
But it was a complete surprise.
Mistaken identity.
I had everything. It was a gun, a firearm by felon of someone who had come in and grabbed a gun and threatened a crowd of bar patrons.
Wow.
And a very scary incident. And I had a police officer testifying that was him. And I sat in the car and there was the gun in the car with him that he put there. I saw him put it there. I went and retrieved it. Very credible police officer. I worked with him for years. And in the end, a surprise witness came from the defense. And it was this guy who said, well, it couldn't have been him because it was me.
You have told me this, but even still,
right?
You're like,
I'm like,
he just came in and confessed.
Who the hell is he? Who is that? I've never even heard of this man in my life. I put the police officer back in. He's like, I didn't even see that guy at the thing. I saw multiple people and he wasn't there. And then the prosecution says, well, can you say for certain it wasn't him? And he's like, well, I can't say for certain, but I know I saw that guy. Not guilty. Wow. And that was one of the biggest surprises of any cases I've ever had, and I couldn't contradict it.
And what do you say?
There was nothing I could do but stick to the evidence of this is what we had, this is what we saw.
Wild.
Our other witnesses saw the same guy, but the non-defendant shows up and says it was me. And there was nothing else I could do, and the jury was like, well, that's reasonable doubt. And it was.
Taking notes for later. That's excellent.
It was horrifying.
The only other one is, you sit at the defense table and you get someone to sit next to you who's not the defendant. You have the big dramatic moment in court. That's him.
Are you sure?
Last thing, I promise. So my professor, who is a practicing attorney, adjunct professor, who teaches this wrongful convictions class, he said early on in his career, he was in the audience in a courtroom observing court. Like he had nothing to do with this case, was just there watching. And one of the eyewitnesses got up on the stand and said, that's him. That's the man in the tan suit or whatever it was. And he's just sitting there. He's like, hey, I'm an attorney. Like, I don't know what this is about. He said it was one of the wildest moments of his life. Because, you have the dramatic. He said it was truly like the heads just turn. And he's just sitting here, he was like, I'm an attorney. I don't know what's happening.
Wow. Yeah. I mean, a lot of court is tedious and dull and repetitive.
But sometimes.
But then
I can't
you get that moment, and it's worth sometimes your whole career. So anyway, like us, subscribe, comment, so that if you can pop up and you can see more multiple episodes, and other people, if you're enjoying it like you, can see it, find it, and get some kind of use out of it, whether it's practical knowledge, some entertainment value, or some actual
if you have any
learning
questions about some of the stuff we talked about,
questions in, put suggestions for later episodes of things that you didn't know and no one told you.
Any cases that don't make sense to you,
let us know.
Yeah.
And we will check out the other defenses in the next episode. We've got some good things planned.
I'm excited. Look.
Stay tuned. Truly subscribe so you can hit the next episodes. And we will catch you later.
Next Tuesday.
Next Tuesday, we're with Tehrani Law LLC, because you never need a lawyer
till you do.